But all of this is just part of the new integrated security space. Governments are sharing suspects. There is a global pool of detainees, of suspects detained in legal black holes around the world to which multiple security forces have access. Canada tips off Syria and Egypt about Canadian citizens. The UK tips off the CIA in Gambia about UK citizens. Macedonia tips off the CIA about a German citizen, and the CIA deports him to Afghanistan, where German officials come to interrogate him. Canadian, Australian, and EU agencies participate with the US in a project called Camelin, in which it's reported their function is to supply dossiers on suspects for the CIA to act upon. And until Canadian courts put a stop to it, the Canadian Security Intelligence Service was traveling to Guantanamo Bay to interview suspects there. At the Yakabuchi inquiry, which is now looking into the cases of some of the other Canadians, Al-Malki, Al-Mahdi, and Nuruddin, the parties were asked to make submissions about what the proper standard of conduct for Canadian officials ought to have been. And the Canadian government's position, its official position, was that it depended on the circumstances, that their conduct should be judged in the special context that pertained after 9/11. Now, the Smart Border Agreement and Action Plan called for new anti-terrorism legislation in the two countries. And as you will know, the U.S. Passed the U.S.A. Patriot Act shortly after 9/11, and it was pushed through Congress without much debate. And in Canada, we got a similar piece of legislation, the Canadian Anti-Terrorism Act, which was also pushed through before the end of 2001. The U.S.A. Patriot Act is a draconian law full of emergency-style powers, which have been embodied in permanent legislation. And in effect, it creates a permanent state of emergency in a democratic country, which is never a good thing. And the same could be said of the Anti-Terrorism Act. Among other things, the U.S.A. Patriot Act amends the U.S. Criminal Code to create new terrorist offenses and new offenses of material assistance or participation in terrorism. So does the Canadian Anti-Terrorism Act. And the imposition of a terrorist framework on the criminal code, I would argue, in Canada, was a completely unnecessary thing because the code has more than enough offenses to deal with acts associated with terrorism. But it had a number of highly undesirable effects on rights in Canada, particularly on freedom of expression and freedom of association. First, it imports a motive element into the criminal law, making the reason why someone committed an act an element which the Crown must prove. Except in sentencing, motive is a foreign concept to criminal, both domestic and international criminal law. And its importation into our criminal code unduly politicizes the application of the criminal law and makes ethnic and religious profiling much more likely. And we've seen this in other countries. In New Zealand, they're prosecuting Maori activists under their new anti-terrorism law. In Mexico, pro-democracy activists have been prosecuted. In El Salvador, water activists. In the US, they're targeting animal rights activists. And in a report that CSIS made sometime in 2002, they identified anti-globalization protesters, anti-abortion protesters, and Aboriginals as potential terrorist groups. The importation of this new terrorist framework, secondly, casts an overbroad net, criminalizing legitimate political dissent and expressions of dissent, and legitimate association in a democratic society. So that, for instance, a farmer's tractor cavalcade on the highway to protest government farm policies could be construed as a terrorist act, or a wildcat strike by nurses could be prosecuted as terrorism. And thirdly, by piling up inchoate offenses like aiding, inchoate offenses like aiding and abetting on new inchoate offenses like financing terrorism or participating in terrorism, it extends the chain of criminal liability in complex, unforeseen, and undesirable ways. So, for instance, under our Anti-Terrorism Act, you can arguably be guilty for selling, having sold milk to Mayor Arar, or been the catering company at a Greenpeace rally. The U.S.A. Patriot Act creates new regimes of secrecy, and so does the Canadian Anti-Terrorism Act. ATA amendments to the Canada Evidence Act replaced the common law doctrine of public immunity codified there. And that's the doctrine by which government officials who wanted to refuse or stop disclosure of information in legal proceedings had to specify a public interest in non-disclosure and prove that that public interest outweighed the public interest in disclosure. Well, that, decades-old doctrine, common law doctrine, has been brushed aside, and in its place, new powers in the hands of government officials give them inordinate control to maneuver and prohibit the disclosure of information in proceedings, including an unfettered right by the Attorney General to issue secrecy certificates, whereby it's a virtually unreviewable right, whereby he can, by fiat, say that information cannot be disclosed in a proceeding. And these new powers apply not only in criminal law proceedings, but in administrative law proceedings, in inquiries like the Arar inquiry, public inquiries, and even in parliamentary proceedings, with the consequent effects on the accused's right to a fair trial, administrative due process, and even the ability of Parliament to get to the bottom of what the government is doing, to get to the bottom of scandals like the sponsorship scandal or wrongdoing like the Airbus or other types of wrongdoing. One of the more insidious and less examined developments in the US-led war on terror has been the incremental construction of a new infrastructure for mass globalized surveillance. And this is a special interest of mine. This is the topic of the book that I've written. And many of the initiatives in the Smart Border Agreement and Action Plan are directed to this. Where before law enforcement and security intelligence agencies would be looking at specific threats in specific circles and following the leads from those inquiries outwards in their surveillance efforts, in the new model of mass globalized surveillance being pushed by the United States, countries are becoming much more ambitious. In the new model, the US and its allies are to be engaged in continuous collection of information on entire populations. And in this model, surveillance is to be used not merely to follow up on leads, but to generate leads. Not merely to catch known terrorists, but or people suspected of terrorism on reasonable grounds as they cross borders or send emails, but to assess the risk that each of us poses to the state, to predict who among us might be a terrorist. And in this new model, systems of surveillance are becoming more and more globalized. Some of them are domestic, some are global, but the domestic systems feed into the global and vice versa. And the US is the country with the greatest control over the whole infrastructure. After 9/11, the U.S. required airlines traveling to or over U.S. airspace to provide passenger information, the passenger information in their reservation systems, up to 65 fields of information, to U.S. agencies. And complying with this demand has required the EU, Canada, and other countries to override their data protection laws. Once they were forced to do this, the EU, Canada, Australia, the U.K. set up their own passenger record collection systems. And the EU has called on the International Civil Aviation Organization, an international forum outside of ordinary democratic processes, to set the international standards for PNR. This is passenger name record information is the name of this stuff, for all countries. And these systems are being expanded to other modes of travel. The US has a system called the Automated Targeting System, which collects PNR data for all modes of cross-border travel and, by the way, stores it for 40 years. And Canada is going to do the same, expand it to other modes. It has a parallel system run out of the National Risk Assessment Center in Ottawa, or NRAC. While we're on the subject of travel, the US has a no-fly list, as you probably know, and Canada recently implemented a Canadian no-fly list, despite objections from the public and from parliamentary committees. Now, the government's protested that this will be a Made in Canada list, that it will be much shorter than the US list, much shorter and gentler, I guess. But the issue is really moot because Canadian airlines, even now, enforce the US list for all flights to or over the United States, as well as for purely domestic Canadian flights. When it was discovered in 2005 that President Bush had secretly and illegally authorized the National Security Agency in the US to use their powers and their tools for domestic spying, there was a huge uproar. Meanwhile, the Canadian security establishment in Canada had been openly authorized by legislation to do the same thing, and hardly anyone noticed it or commented on it, even in the parliamentary committees that reviewed the Anti-Terrorism Act. I said that the new surveillance is being used not merely to follow up on leads, but to generate leads, and not merely to catch known terrorists, but to assess the risk that each of us poses to the state and to predict who among us might be a terrorist. This is being done with a technology called data mining. Data mining is the use of computer algorithms to sort through masses of information for specified criteria, patterns, and relationships. And more than anything, data mining is predictive technology. It's not hung up on accuracy. Really, its developers would have us believe that it's a bit like the stuff Tom Cruise and his colleagues used in the film Minority Report. You know, the film where government agents were able to stop criminal acts before they happened by reading people's minds. This is the same idea, but of course the real world technology falls far short of the Hollywood fantasy, and many of the data mining programs being used today are, racial and ethnic profiling, religious profiling are endemic to them. And perhaps it's reasonable to ask whether the RCMP, like the FBI and the CIA, are running data mining programs, especially in light of recent revelations that the RCMP has been buying vast amounts of commercial data and storing personal information of Canadians that it ought not to be storing. That's a lot of initiatives, and there's many more I could tell you about. But the integration of Canada into this new model of mass globalized surveillance, which is being pushed by the US, is turning our society, if not into a police state, then into something similar, a surveillance society. And it's having a disintegrating effect not only on our democratic institutions, as I've described, but also on our rights to due process under administrative, charter, and international law, our rights to mobility, our freedom from discrimination, our freedom of expression and association, our rights against unreasonable search and seizure, and in some cases, our rights against arbitrary detention, both constitutionally and internationally. Well, I've come to the last subject area that I'm going to canvass tonight, and that is the disintegration of Canada's obligations under international humanitarian law. The war on terror has given the neoconservatives in the Bush administration a golden opportunity to realize some of their fantasies about, and you can find this in their seminal documents, their idea that there should be an increased military presence by the United States in countries around the world where it did not previously exist, and there should be a robust use of military power to advance U.S. interests. And with this has come increased demands by the U.S. for other countries, including Canada, to integrate their military policy and functions with those of the U.S. In Canada, we avoided getting dragged into Iraq, but we have gone to Afghanistan. And with this integration of military function has come a disintegration of Canada's commitments to humanitarian law and the Convention against its obligations under the Convention Against Torture, in conjunction with a similar disintegration of U.S. commitments. Canada has been transferring Afghan combatants that it captures in the war to Afghan detention centers where Canada knows they're being tortured. And Canada also has a Canadian citizen, Omar Khadr, languishing in Guantanamo Bay, who was taken by the U.S. from the same theater of war all the way across the Atlantic Ocean. Other countries have insisted on fetching back their nationals so that they can be prosecuted for any crimes they may have been committed at home or released, but Canada has not. Now, humanitarian law has a history at least as long as human rights law. I'm not going to canvass it, but where human rights standards are important in protecting the interest of human dignity and setting up the framework of our democratic forms of government, humanitarian law has an equally important purpose in governing the conduct of war and in mitigating its most inhumane effects. In respect of Omar Khadr, Canada has a moral obligation, if not a constitutional one, to do what it can on the diplomatic front to ensure that the United States respects his rights under the Geneva Convention, including his right to a fair trial for any crimes he may have committed in the theater of war. We tend to think in Canada that our hands are relatively clean compared to those of the United States. And, you know, speaking of Mayor Arar and Afghan detainees, you know, we also seem to feel that though we may have made mistakes along the way, we've largely redeemed ourselves through an appropriate amount of public concern and government redress. But I think it's a mistake to think that way. In the case where we perhaps behaved the best, the case of Mayor Arar, the inquiry's recommendations have still not been implemented more than a year after they were handed down. And the Harper Conservative government will not even answer questions about what it's doing towards implementation. Meanwhile, there have been a myriad of, as you can tell by my talk today, a myriad of new security measures implemented and corresponding rights eroded. Someone once said, a country is not only what it does, it is also what it puts up with, what it tolerates. Canadians have a deep belief in the benign designs of government. And in this age of terror, I think that we need perhaps to be a little more skeptical, a little more vigilant than that, to keep track of the initiatives that are being put in place in our name, and to fight for the kind of country that we really want to live in. Thank you.